of something very wonderful. It means you will love and be loved for the rest of your life. Quoting Lisa Weed, an eminent psychologist and another. A very warm good morning, respected dignitaries, valued guests, most respected chairs on the virtual dais, intellectuals, faculties, professors, participants, and attendees from all over the globe. Greetings to one and all. We have all gathered here today to kickstart the 11th International Seminar on Family Law's Changing Perspectives, Contemporary Challenges and Solutions, put forward by Kerala Law Academy Law College in association with Center for Advanced Legal Studies and Research, CULSA, the research wing of Kerala Law Academy, which is conducive to ignite nascent thoughts and ideas. Myself, Manupriya Chalan, along with my co-anchor, Akshara Dian, will be the student moderators for this session, and we take the privilege to welcome each and everyone present virtually.
Thank you, Manupriya. To welcome me to establish integrity. It's a moment of great privilege and honor for me to extend a hearty welcome to everyone present on this virtual dais. The Kerala Law Academy, established in 1966, is a center for legal studies, legal research, and law reforms. Founded in 1966, it is the first and was, for many years, the one and only private law institution in the state. Academy has never failed to prove its eminence and merit in various arenas in the field of legal education. To keep up with the legacy, the Kerala Law Academy, in association with Center for Advanced Legal Studies and Research, is organizing its 11th International Seminar.
Before we start the session, I take this opportunity to remember late Dr.N.Narayanan, former director, Kerala Law Academy, the torchbearer of our institution. Thank you all. We now have a promo video on the concept of 11th International Seminar and the legacy of Kerala Law Academy Law College.
Kerala Law Academy Law College, in association with Center for Advanced Legal Studies and Research, is organizing an international seminar on Family Law, Changing Perspectives, Contemporary Challenges and Solutions via virtual mode.
According to Basins and Basins, family is the basic and universal institution. Upon it depends the survival of the society. Family protects the rights and duties of the family members in various aspects. The family law has been one of the most prominent one and has been significantly profound during the last few decades. And it has changed the social conceptions of family, marriage, and the family relations.
The Kerala Law Academy Law College, founded in 1967, is the first and long-standing private institute in the state. It is accredited by the Bar Council of India and is affiliated to the University of Kerala. The Center for Advanced Legal Studies and Research is a research wing of Academy. It helps in supplementing the practice of law by research.
We are extremely delighted to invite you to the 11th International Seminar on 28 May 2022 at Kerala Law Academy Law College, Perurkada, Trivandrum.
Thank you, everyone. Family law encompasses a broad set of rules that are in practice regarding family matters such as marriage, divorce, inheritance, etc. There are some legally enforceable rights and duties that arise when one gives legal validation to the status of interpersonal relationship.
The justification for having laws that affect the most private aspects of our life is to ensure protection of individual rights and to uphold certain norms that are essential to human dignity. This seminar will attempt to explore the different aspects of family law as it plays a crucial role in our society. The application of family law in area is not confined to conjugal matters alone. It also entails finding a resolution to issues similar as guardianship of children and the will, conservation and physical support and other ancillary issues. The purpose of this seminar is to discuss changing perspectives regarding family loss. The seminar will also discuss certain challenges faced by different family laws and the solutions to overcome the very same.
Leaders instill in their people a hope for success and a belief in themselves. Positive leaders empower people to accomplish their goals. This saying is true in all sense for us. Here we have Professor Harindran K. Sir, Principal, Kerala Law Academy, Law College, to officially welcome our guests into the inaugural session. Sir, please.
Good morning to all. Thanks for the nice words of Akshara DN. At the outset, I am paying the most respect and honor to our beloved founder, director, our leading and guiding lamp, Dr.N.Narayanan, sir. Respected Professor Dr. Anil Variat, Registrar, MNLU Mumbai, Professor Dr. V.S. Elizabeth, Vice Chancellor, Tamil Nadu National Law University, Professor Usha Tandon, Dean and Head of the Faculty of Law, Delhi University, Dr. Sindhu Tulasidharan Ma'am, Professor and Head of Department of Law, University of Kerala, Karivattam campus, Advocate Dr.N.Narayanan, sir, Director of this institution, Professor K. Anil Kumar, sir, Director, Student and Faculty Affairs, Kerala Law Academy, Law College, then Vidya V.V., Assistant Professor, Kerala Law Academy, Law College, and other distinguished invitees, my dear colleagues, students, parents, and all other well-wishers of this institution. First of all, a warm welcome to one and all. As you know, we have virtually joined here to take part in the 11th International Seminar on Family Law's Changing Perspective, Contemporary Challenges and Solutions, well organized by Kerala Law Academy, Law College, in association with Center for Advanced Legal Studies and Research. Anyway, this function is presided over by Professor Dr. Anil Variat. He is the Registrar, Maharashtra National Law University, Mumbai. He also serves as the Director of the Center for Research in Criminal Justice. Before joining Maharashtra National Law University, Mumbai in 2019, he served as the Professor, Head of the Institution, and Deputy Director at Amity University Law School, Mumbai. He also served as the Professor and Head of the Department of PG Studies at Maharashtra National Law University, Mumbai, and the faculty in charge and a coordinator of SNDT, Women's Universities Law School. With over 2 decades in the legal profession, he has authored more than 4 books and 30 articles on various topics and aspects. He will deliver the presidential address here. On behalf of Kerala Law Academy, Law College, and Center for Advanced Legal Studies and Research Center, and everyone present here, I profoundly and profusely welcome you to serve this function. We have Professor Dr. V.S. Elizabeth, an eminent personality here. She is the Vice Chancellor of Tamil Nadu National Law University. She has been a member of permanent faculty at the National School of India University, Bangalore. She has numerous publications to her credit, featuring themes of gender, feminism, etc., etc. We are truly blessed with her gracious and august presence. Mom, we are eagerly waiting for your inaugural address here. On behalf of Kerala Law Academy, Law College, and Center for Advanced Legal Studies and Research, and everyone present here, we warmly and cordially welcome you, Mom, to this institution. Then we have another eminent personality, Professor Dr. Usha Tandon, Dean and Head of the Faculty of Law, Delhi University. She served as the Professor in charge of Campus Law Center, University of Delhi, with the teaching experience of more than 30 years. She is a world-renowned scholar for her work on human development, focusing environmental protection and women empowerment. She is the recipient of World Population Day Award 2000 and also Inaugural She 2019. Mom will here deliver the keynote address. On behalf of Kerala Law Academy, Law College, and Center for Advanced Legal Studies and Research, and everyone present here, I extend a pleasant and pleasurable welcome to you, Mom, to this session. Dr. Sindhu Tulasidharan, Ma'am. She is a professor and head of the Department of Law, Kerala University, Karivattam campus. She is an eminent academician with authoritative knowledge in the field of law. Every time we conduct any program, maybe seminar, webinar, competitions, or any other academic activities of like nature, Mom will extend all support and cooperation to us. Mom will deliver the special address here. In the name of Kerala Law Academy, Law College, and Kalsar, and all present here, I extend a heartfelt welcome to you, Mom, to this function.
Thank you, sir.
Thank you. Advocate Dr.N.Narayanan, sir, he is the director, Kerala Law Academy, Law College, and a special government pleader, Forest Department at High Court of Kerala, member of Bar Council of Kerala, and he is the pioneering spirit behind this institution and always keen to foster and promote the academic environment and peaceful atmosphere in this institution. It is indeed my pleasure to invite Advocate Narayanan sir to this function. Professor K.N. Kumar sir, Director, Students and Faculty Affairs, Kerala Law Academy, who is a constant source of support and motivation, and he is the chief executor of this program. I heartily welcome Professor Anil Kumar sir to this function. Srimati Vidya V.V., Assistant Professor, Kerala Law Academy, Law College, who will be rendering the vote of thanks to this section. I extend a hearty welcome to you, teacher. Last but not least, I express my sincere thanks to the student moderators, Manu Priya Chalan and Akshara Dian. And I also take this opportunity to welcome all the faculty conveners, especially my friend Professor Anil Kumar Ji, Kerala Law Academy, Professor Ajit Nair L, Dr. Dakshina Saraswati, the convener of this program, Advocate Arya Sunil Paul, Shri Varun Dev, yes, and also I especially welcome the student conveners, Gautam Vishwam, Lakshmi V.S., Anjita Unnithan, Devika S. Ashwin Rajiv, Anakha, yes. Gauri H. Nandakishore, yes. And Namita Baby Benedict. I would also welcome all the faculty members, students, parents, teaching and non-teaching staffs, and administrative and technical staff, and also all the well-wishers of this college. Thank you once again.
Thank you so much, sir, for your warm words of welcome. I also take this opportunity to graciously welcome you two into the session, sir.
Thank you.
Thank you, sir. Now, we have Professor Dr. Anil J. Vairad, sir, registered MNLE Mumbai with us. Sir also serves as the Director of Center for Research in Criminal Justice and a Chair Professor and Director of Justice in Environmental Laws. With over 2 long decades in legal profession, he teaches constitutional law, corporate governance, international humanitarian law, comparative public law, and environment law. He has also authored 4 books and more than 30 articles. I take the privilege to invite Professor Dr. Anil J. Vairad, sir, for the presidential address. So please.
Thank you, Manipriya and Akshara. My dear friend and your principal, Professor Harindran, Chief Guest of the Day, Professor V.S. Elizabeth, other guests of honor, Professor Usha Tanden, Sindhu Tulasidaran, Professor Vidya, and Dr. Daksha Saraswati, who was coordinating with me, Advocate Nagaraj, Professor Anil Kumar, all the faculties and other participants who have joined this program on this online platform. A warm good morning to you all. At the outset, I take this opportunity to pay my tributes to the great legend, Dr.N.Narayanan Nair, whom I also had occasion to meet a couple of times. And though I am coming on this platform, online platform, for the first time in Kerala Law Academy, I recall around about 25 years back, I was in Law Academy, Law College, when I was practicing advocate to judge a moot court trial session. And the contribution of Kerala Law Academy, Law College to the legal education in Kerala in particular and India in general is really remarkable. And being a person from state of Kerala, I also always feel proud of the institution, because wherever I had worked and I have gone, before the, I'll tell you, before the advent of the NLU system itself, the legal fraternity all over India knew Kerala Law Academy, whether it be in Delhi, Allahabad, Kashmir, Bombay, or anywhere. They knew Kerala Law Academy. So I always felt proud of the institution, and I feel that I am honored to be invited here as a guest, and also I am honored that I am here in the midst of eminent personalities in this subject. And the theme of the seminar itself is very relevant. And I know the challenges and the road ahead you will be discussing in the forthcoming technical session. So my role is just limited to give a opening remark on the subject. I would like to share a few thoughts which I always had about the personal laws in India, particularly. As you have introduced in the introduction itself, you have mentioned the personal laws are something which connect two persons on certain aspects of marriage, blood relations, and affinity, and it regulates the relationship with respect to marriage, divorce, maintenance, succession, minority, guardianship, etc. So let us take all these factors as minor social institutions. The nature and character of all these social institutions like marriage, divorce, family, everything has undergone a lot of change. But I doubt whether the family laws in India had been so responsive to the changes and changing needs of society. There have been certain challenges that you will be discussing, but what I feel the most important challenge with respect to family laws in India is, first is the misunderstanding about family laws. Second, I feel overemphasis of religion into family laws. And third is lack of political and judicial will. To summarize, I shall tell you. See, I have read in many books that the origin of family law or Hindu personal laws can be traced in Vedas and Puranas. It's a misunderstanding given to us. No Veda speaks about the form of marriage, though there may be some isolated discussion about different forms of marriage prevalent at that time. Secondly, the Purans like Mahabharata and Ramayana speaks only about the marriage of Lord Sri Ram with Devi Sita. Similarly, Mahabharata, it speaks about the marriage of Pandavas with Draupadi and the marriage of Lakshan. So many other few marriages they speak, but we will find that there had been different forms of marriage, right from Swayamvara to Rakshasa form of marriage, where an element of force is also coming to. So we will find that there had been at no point of time there had been a codified system of marriage or not to speak about divorce at all, marriage or other personal laws in the Indian jurisprudence. And if you take the ancient Indian jurisprudence, you will find that the public law realm and private law realm have been treated in a different fashion because the state was concerned only with the public law and the private law was evolved. The private law evolved because of usage. Every usage comes because of the need of the society at a particular time, at a particular place. It is equal with the Muslims, it is equal with the Hindus or Christians, any community. You take the case of Hindus, the Hindus in different parts of the country have different forms of marriage, where you may find Saptapadi. In some places you don't find Saptapadi. Some places you find Agni Sashi. In some places you don't have the Agni at all. And within the one state itself, different forms of marriages, different forms of divorce. Again, divorce also, if you take the traditional way, different forms of divorce, different forms of inheritance, different forms of adoption, everything prevail. See, we are a community which entertained matriarchal and patriarchal systems simultaneously. You will find Muslims in India, at least in Kerala, who followed matriarchal system of inheritance when it is totally against the concept of Islamic law. Right. So similarly, there are communities who can marry the cousin, but there are some communities where uncle marries the niece. So never speak about a codified system of personal law ever existed in India, and the religion had anything to say with that. No religion, especially the Hindu religion, has never spoken about the form of marriage. It has not spoken about the form of divorce, but we have been given to understand that family laws are influenced by the religion. It's a wrong notion we are having. How it has come? It has come only in the medieval period when the Britishers came to India and they tried to impose or superimpose their legal system. Basically, being the traders, they never thought of reforming the personal laws over here. Their idea was to reform the civil law to the extent of trade and commerce, which they were practicing, and also to make the English criminal law applicable to disputes where Englishmen are involved because they were not happy with the type of punishment we had in those days. it was not meeting the English standards. But after some time, they felt that without having certain contribution into the or interference in the civil law regime, these things cannot function. So all these things happened, with the establishment of high courts in the year 1864 and the first law commission establishment, and you will find several enactments like Indian Divorce Act, Dissolution of Marriage Act, earlier instances where the state used to interfere with the religion and try to codify it. And the judges, especially the English judges, they were not well versed with the local customs and the usage of the people. Then I don't know, in a planned manner or systematic manner or by default, interpreting or interpretation of personal laws and supplementing the code with the jurisprudential aspect of personal laws was entrusted to Maulavis, mullahs, and pandits. So they have misinterpreted the law. A Brahmanical version of Hindu law and a Western version of Islamic law has been imposed over our system. And that I'll tell you, you may refer to a case in 1866, that is Aga Khan case, where the court has conveniently considered Khoja community as Muslims and the Pushti Marg as Hindus, instead of recognizing them as a different, distinct set of religious practices. Okay, so this happened. Again, following year in the Bombay itself, State of Bombay versus Narsu Appa Mali, a very old case. There the question came with respect to the constitutional validity of Hindu bigamous marriage Prohibition Act. So there are two questions court has to inquire. One was whether the non-public laws of Hindus or any other religious denomination is law within the meaning of Article 13 and 372 of the Constitution. Secondly, whether an alteration or modification done with respect to a particular practices of religious practice of one section will violate Article 14 of the Constitution, where the court, in the first point, court answered in the negative, and in the second point also answered negative, and thereafter court slowly taken over the task of codifying the personal laws. But having a common personal law for a country, a common civil for the country, idea was muted even before independence. And one of the, you are aware that one of the most prominent advocates of uniform civil code in India was none other than Dr. Babasaheb Ambedkar. He resigned from the Jawaharlal Nehru cabinet on the question of dispute or difference with Nehru with respect to codification when the Hindu code was passed. Okay, so that's why I told you at some point of time, religion has unnecessarily been mixed up with the personal laws, and because of religious interference and religious mix-up, the political will fails. And when the political will fails, naturally the judicial will also fails. That you have seen in the case of Shabanu case, when there was a judgment by judiciary, the community, a particular community was not able to sustain or digest the judgment. Then what happened? The result was the passage of Muslim Women Protection Divorce Act, right? So again, you have seen the Mary Roy case, the repercussions what the Mary Roy case had brought into certain sections of the society, especially in the state of Kerala, and recently the Triple Talaq case. But what I would like to tell you is that time has changed. The personal laws have evolved at a time. Marriage and other family relation was limited to a particular area within certain communities. Now these institutions have grown so far beyond, it has become internationalized. The Muslim law, Indian Hindu law, and the Christian law in India, when it evolved, the Hague Convention was not a threat. Understand, the children's right under Hague Convention was not even envisaged. Now the changes have come. It is posing challenges to the development of family law, not only in the national sphere, but also in the international level. It is time that we should, as a community, sit, think, and reform the laws without hurting the sentiments of any stakeholder. I would like to say any stakeholder, for which a sensitization is required, and the demand for reform should come from the community, from the stakeholder themselves. With these words, I wish all success to this seminar, and it will yet another be a milestone in the contribution of Law Academy to the legal academia in India. Thank you very much. Wish you all the best.
Thank you, sir, for filling us with the awe and joy of your wisdom. Now, we have the esteemed presence of Professor Dr. V.S. Elizabeth Ma'am, Vice Chancellor, Tamil Nadu National Law University. Ma'am is the fourth Vice Chancellor of TNNLU. Ma'am was one of the founding members of the governing board of IALS. In 2012 to 13, she was appointed as a member of High-Level Committee on Status of Women by Government of India. Ma'am also carries the legacy of teaching feminist jurisprudence to both the undergraduate and graduate students at NLSIU. I'm deeply privileged to invite Professor Dr. V.S. Elizabeth Ma'am for the inaugural address. Ma'am, please. Elizabeth Ma'am, am I audible?
You are, but I can't unmute myself. Goodness.
You are also audible to us, madam. You are audible.
I'm audible, is it?
Yes, yes,
okay.
madam.
Yes, ma'am.
Okay, thank you.
Okay.
Good morning, everyone. And at the outset, let me thank you all for inviting me to inaugurate this 11th International Kerala Law Academy Conference on family laws, changing perspectives and challenges. Sorry. It is indeed a privilege to be addressing all of you here this morning. What I would be speaking on is with regard to the issue of domestic violence and its impact upon various members of the society. I must say, I really appreciate the facts that Dr. Varyat has placed before us in terms of the diversity of practices that prevail in our country. And also the history. Just one minor correction. Colonial rule began in the modern period, not in the medieval period. And it is, of course, absolutely right what Dr. Varyat said, that it is with the coming of the British and after the Battle of Plassey, when they got to have to administer judicial matters in the Bengal province, that we have the search for what is the law and how it is to be administered. And even as we have these various debates going on in our country currently about the need for a uniform civil code, I think it is important to keep in mind that we are not a country like, France or Germany or England is. We are a subcontinent. We have a wide variety of cultures and peoples that live here with their variety of practices. Not all practices are gender friendly or bring about gender equality, but that doesn't mean that a uniform civil code will automatically take care of those things. So maybe there is need to codify, but codification cannot be codification of the Hindu law and imposed on all the other communities that exist in India, because keep in mind that it is not just the Hindu, Muslim, and Christian communities. whose laws have already been codified through the legislations that we have, there are a wide variety of other communities that exist in this country. So it's important, and in the cause of unification of the country, it should not result in violation of the basic rights of the peoples of this country. After all, without the people, there is no country. We need to keep in mind that this geographical boundary that has been drawn up to create India is, a new one, did not exist before 15th August 1947. And therefore, we need to keep in mind that the history of this subcontinent is much older, and the peoples who live here are much, much older than this country, which has been brought into existence. We are only celebrating the 75th year of independence. Having said that, I also wish to thank Mr. Varyuth for drawing attention to the fact that, there are so many changes that have taken place with regard to the institution of family, and that the family is a social institution. And for us who are present here as students and teachers of law and people who research in the area of law, it is very important to keep in mind that the law has to respond to society and not the other way around. Law might initiate changes, but law cannot force changes. What you will have is only more fundamentalism that will emerge when law tries to force changes upon people, changes that the people are not familiar with or not comfortable with. So it's important that we do change the way people think about family, about marriage, in order to bring about the changes in law that will bring people together. By putting the law before the changes in society, we are kind of dooming the entire project to failure. All you got to do is look at the various socio-religious reform laws that the British enacted and what we have enacted since independence, and how far we have failed. Take the Dowry Prohibition Act, take the Hindu Widow Remarriage Act. None of these have succeeded in either abolishing the practice of dowry. It is, in fact, as recently as just a couple of days back, we had the judicial decision on dowry practice in Kerala, right? So Kerala, which is otherwise being celebrated as a state where you have almost 100% literacy, women are highly educated, women are all employed, etc., is a state we have so much of sexual violence against women by people in positions of authority, people who are public figures, as well as domestic violence. You also must notice that the sex ratio is also falling in Kerala, right? So you have to keep these factors in mind before we start ushering in, making another law, which will not bring about the desired changes. What we need to do is change the way people think. So in that context, it is important that we as a people, and especially as students and teachers of law, look at the law through an interdisciplinary perspective. You can't understand social institutions without consulting what sociologists have to say about these social institutions. It is not the law that created these institutions. It is a society that created these institutions. So unless you understand these institutions from the perspective of a sociologist, and you use the research tools that sociologists use, understand the theories that sociologists have formulated, we will be doing great harm by enacting laws and only looking at laws through the eyes of, especially positivist lawyering. In fact, another thing that we should do as students of law is to examine these laws from a feminist perspective, using feminist legal methods, asking the woman question: what will be the impact of these changes in law, of any codification of law upon women and their lives? We need to use the feminist practical reasoning method to understand why is it that women stay in families where they are subjected to abuse. Why aren't women who are being subjected to dowry violence fleeing from those families? Why are they continuing to remain there? Why are they not using Section 498A? We need to ask these questions in order to understand how women are practically responding to these challenges in their marriage and family situations. We cannot presume what women want. We need to hear from women what they want. And that is the reason why you need to use the feminist legal methods. And then the third feminist legal method is consciousness raising. Not the raising the consciousness of women. They know what is happening to them. What you need is raising the consciousness of society to understand that domestic violence that they're subjected to is not the result of women failing to do their duties. It is not the fault of individual women, but rather that is the result of the kind of family institution that we have, the kind of marriages that we have, the laws relating to marriage and family, which all are actually endorsing and supporting patriarchal values, patriarchal systems of family and marriage. And obviously that is about dominant male vis-a-vis a female that has to be subordinated. So it's very, very important that we use these sociological perspectives and the feminist legal methods in order to understand the problems that we see in the institutions of marriage and family. And therefore, before we rush into making any more new laws, it is also to understand how these laws have impacted women till now, and what has been the consequence for women, for children, and for other members of our society. The very structure of family is undergoing a change, and we need to acknowledge it. It is not one male, one female, and half a dozen children. We are talking about families consisting of different genders. We are talking about families where there may be a child or no child. And we're talking about children either being born into that family through those people who are married, or children who are being born through surrogate mothers, children who are being adopted. We need to keep in mind all this diversity of the changes taking place in society. And that cannot happen by looking at marriage and family through the eyes of a positivist lawyer or law teacher. Because that is assuming that there is no change and everything is absolute, and the way the law teacher sees it or the law researcher sees it is the final word on it. This is the reality that there are changes, and we as students of law, practitioners of law, are assuming that law functions in a vacuum. Law doesn't. Law is another social science. Law is another instrument of society. Society is not the instrument of law. And the purpose of law is to ensure that justice is done. So when you look at the question of domestic violence, the reason that we need to respond to domestic violence is not only because of the fact that the fundamental rights of women are being violated. A woman's right to life, that is a very fundamental right of all human beings, is under threat when there is widespread domestic violence or domestic violence in that marriage. No family, no marriage must be preserved at the cost of human life. Now, when we say domestic violence, one impact is the impact upon women. The impact is physical, mental, emotional, social, and in various other ways, as well as economical. Because women who are subjected to domestic violence oftentimes are so brutalized that they can't go to work, which means that they lose wages on the one hand. On the other hand, is that if they dare to go to the hospital for treatment, there is a cost upon the health system that we have, right? It can be small injuries to serious injuries. It could be physical injuries. It could be mental injuries. And most women who are subjected to violence do not actually seek psychiatric or even psychological help, because they're made to believe that it is all their fault. Then there is, of course, the emotional cost, resulting in very often women turning to some kind of substance abuse. Either they are consuming painkillers on a regular basis just to kill the pain, which is making it impossible for them to live, or they're consuming alcohol or drugs. And keep in mind, we're not talking about women who are living in the slums. We have women who are police officers, women who are politicians, women who are IAS officers, women professors. They're all subjected to domestic violence. So let's not live in this myth that domestic violence is only by some drunken man coming home and beating his wife because she's not giving him money to go and get drunk. No, domestic violence is happening across all classes, castes, and communities. And it is widespread. It is very important. Dowry-related violence is only one form of domestic violence. So dowry-related violence isn't some exclusive, exotic practice. It is just one of the ways in which domestic violence is experienced in our country. And keep in mind that many of those who are subjected to domestic violence end up killing themselves or are killed. Who are the others who are subjected to violence? Children. Domestic violence impacts children drastically. Very often, foolishly, people keep advocating that a woman should stay in an abusive, violent relationship for the sake of the children. Friends, let me tell you, that's the worst thing you can be doing to a child. For a child to grow up watching her father beat up her mother or humiliate her, abuse her physically, emotionally, and otherwise, is to tell her this is what marriage is. And she will either decide not to marry, because if this is what marriage is, then why would anybody voluntarily enter into marriage? Because unless you're a sadomasochistic person, you will not think that, marriage is a fantastic thing to enter into when you're experiencing that on a daily basis. Or the opposite will be, she will grow into a survivor or a victim of domestic violence herself. She will automatically look for a man who's exactly like her father and marry him, and then the cycle will repeat. She also will be subjected to violence. So unless she breaks that cycle of violence by getting out of that violent relationship, you will find that this is something which will keep going on generation after generation. And young boys who watch their fathers beating up their mothers do not like what their fathers do to their mothers. They want to defend, they want to protect their mothers. But they end up as perpetrators of violence themselves when they're in a relationship or they get married. I remember one such incident in the early history of, National Law School. I used to be the warden, during my first 5 years at NLS. And during that time, I closely interacted with the women students who were in the hostel. And I remember one student telling me that her boyfriend was beating her up, that he came from a family where there had been domestic violence. His mother and he used to be locked out of the house in the middle of the night because his father, thought he is the boss of the house. And the whole night they would spend outside that door. A young boy like that who defended his mother ended up as an abuser himself. He was beating his girlfriend. So for all those who promote that, a woman should stay in a violent marriage for the sake of the children, I would say you are doing the worst thing possible by advocating that. And any woman who continues to stay in a violent relationship is doing great harm to the psychological, emotional, and physical well-being of her children. These are terrible costs to pay. And such children perform badly in school. So if you try to look at poor performance by children in school, you will find that either they're being sexually abused at home or they are in a domestic violence-based family. It is these things, because children don't know how to get out of it. They don't know how to deal with it. And therefore, the one way, they are expressing their anguish is by not performing in their studies well. Which is why it is so important that we do as teachers, whether at school level or at the college level, to look into the background of the students who are not doing well. Especially if they have an academic record which was good, or they seem to be really bright children, we seriously need to look into it. And that's the reason why I am no advocate. I see some of these programs we have on TV, this actress Lakshmi from, my generation conducts these, little coming together of families on TV. And I'm horrified. The woman is saying how terrible her life was, how she even felt threatened in that family. And here is Lakshmi saying, for the sake of the children, go back to that man. I mean, are you saying now let him start beating up the children as well? Very often when women leave in our country and abroad, when women leave marriages, it is not because, they're all whimsical. They leave it when they feel that their lives are under threat. They have been bearing the violence. You must remember many cases of divorce that are there in these family courts are by women who have lived in marriages for 15, 20 years or longer. Oftentimes, they're being taken by their children to the court saying, enough is enough, ma, you have borne a lot of it for our sakes. Now we are grown up, we are employed, you don't have to live with this abusive man anymore. You need to understand this is where this whole thing about divorce comes from. And which is why I get terribly perturbed when people talk about abuse of, misuse of Domestic Violence Act or Section 498A or divorce. You need to give me statistics. Don't simply talk about it. Because a case is not proved in court doesn't mean that that violence did not happen. It's happening within the home. Where are you going to get witnesses from? Who is going to be a witness? Will his father and mother come and say that he's beating up their daughter-in-law? They're also probably participating in that themselves. So just because there is not enough evidence, because remember, excepting for the 2005 Domestic Violence Act, 498A goes to the criminal trial. And in criminal law, you should know that the proof is really high, proof beyond reasonable doubt. To prove beyond reasonable doubt, all the defense lawyer has to do is cast a doubt in the mind of the judge. And that doesn't mean that this violence is not happening. Whereas in the family court setup and under the Domestic Violence Act, it starts as a civil proceeding. And there's a very good reason it starts as a civil proceeding. Because women are not seeking that their husbands are imprisoned, as 498A would require. Women are not seeking divorce. All they want is the violence to stop. And the reason we have the 2005 Act enacted as it is because it is a result of practitioners like Flavia Agnes in Mumbai and Indira Jaisingh and the Lawyers Collective in Delhi, Mumbai, Bangalore. Even before the 2005 Act came into existence, they did not resort to 498A. They resorted to the Civil Procedure Code. They sought protection orders. They sought injunction orders. Because that is all the women wanted, that the man will not come near them and beat them up or beat their children or come to their office and humiliate them or make humiliating calls or disturbing calls, harassing them. And therefore, that is all that they sought, protection orders, injunction orders. And the Domestic Violence Act includes these two, along with, of course, custody, maintenance, and other things, which a woman needs immediately as relief. Divorce is only the later stage. So when we look at the prevalence of domestic violence, just look at the National Family Health Survey for data. And you know that more than 60% of women are experiencing domestic violence on a daily basis, whether they are in the villages or in the cities, whether they are in the small towns and cities or in the metropolitan and cosmopolitan cities. So understanding that domestic violence is so widely prevalent, we also need, therefore, to acknowledge how widely prevalent is a consequence of domestic violence for the women and children, and for any elderly people who are living in those homes who are subjected to domestic violence. It's also important to keep in mind it is not only married women who are being subjected to domestic violence. You have single women who are not married, living with their families, who are also subjected to domestic violence. And as a result, the fundamental right to life, right to live with dignity, is something that we have failed to guarantee for them, something which they're unable to exercise, something which is not real for them. So when we talk about constitutional rights, etc., we are being so hypocritical when we do not address these issues. It's very important we do not uphold the family simply for the sake of upholding the institutions of marriage and family. It is important that we preserve the life of every individual. Remember, no society, no country can exist if there are no individuals, no human beings. With that, once again, thank you all for hearing this opportunity to share my thoughts on domestic violence and family law in general. Thank you.
Thank you so much, ma'am, for providing us the opportunity to imbibe your words of wisdom and enlightening us with the very same. Next, we have the presence of Professor Dr. Usha Tandon, ma'am, Dean and Head of Faculty of Law, Delhi University. Ma'am is an eminent professor of environmental law, population law, gender justice, and family law. With a teaching experience of more than 30 long years, ma'am is a world-renowned scholar for her work on human development, focusing on environmental protection and women empowerment. Ma'am is also the recipient of World Population Day Award 2000 and a phenomenal She 2019, and also served as the professor in charge of Campus Law Center, University of Delhi from the year 2013 to 2019. I am extremely delighted to invite Professor Dr. Usha Tandon ma'am for the keynote address. Ma'am, please.
All right, thank you, Manupriya. There is a box which is coming here. Am I audible?
Yes, ma'am, you are on.
Okay. Well, it was interesting to listen Professor Elizabeth, who spoke on the sociology of law, with particular reference to the social aspects of domestic violence. And Professor Anil G. Variat, who talked on personal laws and the diversity in the personal matters. Well, as we all know that in India, as a matter of fact, we do not have family law. What we have is personal laws. And there is a lot more literature on what do we understand by personal laws. Well, at the outset, I congratulate the organizers for having organized this 11th international seminar on a theme which otherwise is treated to be as traditional law. And also thankful to the organizers for making me a part of this event, for delivering the keynote address. I had seen the concept note wherein various themes very exhaustively have been mentioned, as many as 36 sub-themes have been mentioned therein. And if I talk about yesterday's email, then I found that each one of those sub-themes have also been given a brief introduction. I'm going to be very specific and focused on one of the sub-themes of this seminar, which relates to number 24, and that is the correlation between family law and criminal law. I believe much general things have already been said by my two predecessors, and therefore, though I want to say something on that, but looking to the time constraints, I will focus more on what I intended to say and not what I am tempted to say. So, coming on the correlation between family law and criminal law, I'm going to address this primarily from the point of view of a teacher or researcher rather than the advocate or a lawyer, right? Now, we all know that family law, which regulates the family relations, gives relief to the aggrieved party in the form of decree or the order. These are the reliefs. We may ask to the court for a decree for the nullity of marriage, decree for divorce, order for maintenance. These are civil remedies when we talk with reference to the family law. Now, criminal law, wherever it deals with family law, it relates, it prescribes, as we know in general, punishment. Maybe either the fine or the imprisonment. Now, the criminal law governing the family relations may be contained in the matrimonial law itself, or it may be contained in a pure criminal code. Maybe even the students, participants who are connected with it may be aware of that if I talk about IPC, there is one chapter which is exclusively devoted to, the title of that chapter is Offenses Relating to Marriage. So in the Indian Penal Code, we are having the offenses relating to marriage, 493 to 498A, 7 sections. Prominent among them are bigamy, cruelty, and adultery, which has now been struck down. Now, the criminal provisions may be contained in the matrimonial law itself. If I take the example of Hindu Marriage Act, then you must be recalling that there are certain sections in the Hindu Marriage Act which talks about certain punishment. Section 17, Section 18 of Hindu Marriage Act. I will come on what situation they talk about the punishment, right? Then there is, I can give you the example of another specific matrimonial law, Prohibition of Child Marriage Act, 2005. And before that, Child Marriage Restraint Act of 1929, Sarda Act, that regulated the age at which the boy and the girl can marry, but then it also prescribed punishment. So criminal law in family law. So this is how criminal law and family law interject with each other, right? Now, the point which I want to make here in this small address starts now. And that is that there are two legal terms which we use when we talk about family relationship, particularly the spousal relationship. And we should be very careful in using those legal terms. What are those legal terms? One is validity, and another is legality. If I'm talking about spousal relationship, then there can be 4 circumstances. Spousal relationship from the point of view of validity and legality can be divided in 4 categories. One, very simple. A relationship may be valid and legal. Second classification is also equally easy. That is, a relationship may be invalid and illegal. Now, coming to the third, you will find that a relationship may be valid but illegal. And the fourth, it may be invalid but legal. I will give you an example of each one of these. Coming to the first two, which are very easy. A relationship between a man and a woman is valid as well as legal. Say if I take the example of relationship which is known as marriage. For the sake of simplicity, because we are not having family law, we are having personal laws. And therefore, in that personal laws, if I take Hindu law, then I will say, if the boy and the girl fulfill all the requirements of Hindu Marriage Act, their relationship as a husband and wife is valid. And at the same time, it is legal. Why? Because we do not find anything in any criminal provision which says anything as far as legality is concerned. When we talk of validity, we are talking about civil rights. If I'm saying the relationship between husband and wife is valid, means law recognizes them as husband and wife, gives them rights as a husband and wife, imposes obligations on them as a husband and wife. Their children are legitimate. These are some of the prominent implications of saying that a relationship is a valid relationship. But when we say the relationship is a legal relationship, that means if you have entered in this relationship no fine, no imprisonment. It is as simple as it is. No fine, no imprisonment. Now coming to the second, any relationship which may be illegal, invalid, as well as illegal. Herein we can find, if I can give you the simple examples, those who are student of family law or those who are not, they must also be knowing that among Hindu law, Hindu personal law, one person can have only one spouse at a time. However, person is married and married another time. Bigamy is committed. I'm talking about bigamy. Okay. Now, the bigamous marriage is invalid. It is invalid. But this bigamous marriage is also illegal. Why? Because there is section 494 in the Indian Penal Code, which says it is illegal. Punishment is provided therein. Right? I can give you another example of this, again from the same act for the sake of simplicity, Hindu Marriage Act. Hindu Marriage Act prohibits pindas and prohibited relationship. If they violate this, if two cousins in Hindu law, as per Hindu, two Hindu cousins marry, it is invalid marriage under Hindu law. This is also illegal, but where? Under IPC? No, not under IPC. It is illegal under HMA itself. Section 18 of Hindu Marriage Act makes it illegal also by prescribing punishment therein. So here is the example of invalid as well as illegal. Now let me give you the example of that relationship which is valid but still illegal. Okay, which is valid but unlawful, attracts certain criminal liability. Best example is before 2005, before the enactment of Prohibition of Child Marriage Act, even though the law prescribed minimum age of marriage, but if there was a violation, but marriage was a perfectly valid marriage. Child marriage before 2005 was a perfectly valid marriage. But at the same time, this marriage was illegal also, child marriage. Where, if I talk about Hindu Marriage Act, under the Hindu Marriage Act itself, under the before 2005 Sharda Act itself. Now, I remember there happens to be one advertisement on the TV and the social media which says marrying before this age is kanuni aparadh, is an offense. The same thing which I'm saying is illegal, but marriage is valid, relationship is valid. Okay. Now take me to the fourth, where the relationship is invalid, but it is legal. It is legal. If you want to have an example, I can give you example. Law says, all laws, but here I'm mentioning Hindu Marriage Act, says insane persons suffering from certain mental disability should not marry. However, if they marry, the marriage is invalid in the sense of voidable, but no punishment. There is no punishment for that. It is not what I'm saying, illegal marriage. Okay. Now, I relate it with the basic understanding of family law when we study this in our classrooms, particularly at the LLB level. Now I take you to the changing perspective of family law. Okay. The first changing perspective which I'm taking is the recent judgment of the Supreme Court of 2018, Joseph Shine case. I hope all of you have recognized the law which I'm talking about is Section 497, Indian Penal Code, which has been struck down by the Supreme Court. And in common parlance, we say adultery is decriminalized. Adultery is no longer a crime. Yes, that is the impact of this judgment, but understand it carefully from the lens of validity and legality. So what is the impact of this judgment? That is that if a woman, a Hindu wife, say for example, I'm just carrying it, the Hindu examples for the sake of simplicity, even though we can take other examples also. If a Hindu wife is having illicit relationship with another man, by virtue of 2018 judgment, her paramour cannot be prosecuted. Why? Because adultery is no longer illegal. But now the second question is, does it mean that the relationship of this Hindu wife with her paramour has also become valid by virtue of Joseph Shine judgment? Answer is no. Joseph Shine judgment has nothing to do with the validity of the relationship between the married woman and her paramour. Its scope is limited only to the legality of that. That relationship is still invalid, and whatever remedies are available in this example to the husband, divorce, judicial separation, or whatever other remedies are available, they are available to the husband. But here my emphasis is not on the remedies of the husband. My point here is the relationship of this wife with her paramour. Okay. Now continuing the changing perspective, if I take another example of live-in relationship, right? So far, we do not have any legal definition, either by the legislature or by the judiciary, on live-in relationship. The law is still at this stage of evolution, though we do have judgments from the courts wherein they have said that if two adults, if a boy and a girl of age are living together and are cohabiting together, it's not an offense. That means their relationship is not illegal. Their relationship is legal. Okay. But does it mean that their relationship, because of this judgment of the court, is also valid? The answer is no. Because if a boy and the girl of age are living together and cohabiting together, can they go to the court and ask any right of the spouse, husband or wife? The answer is no. If any child is born to that parent, what is the status, legitimacy from the point of view of that child? Is it equal to that which is born out of the lawful wedlock? Again, the answer is no. Be very careful. There are certain judgments wherein the Supreme Court seems to have said that, but that is in a different context. And there's nothing new in that judgment of the Supreme Court. There are certain judgments wherein it has been said that if the boy and the girl have been living together, cohabiting together for a long period of time, and then if any child is born, the child may be treated as legitimate. There's nothing new in that. Why? Because right from the very beginning, we are having one section in our Indian Penal Code which says that long cohabitation, consistent, continuous cohabitation between a man and a woman raises a presumption of the validity of marriage. So it is in that context we can say that if the boy and the girl, presuming both are unmarried and of age, are living together for a long period of time, that old presumption of the Evidence Act makes their marriage first valid only then what we can talk about, the legitimacy of children we can come on, right? So in the first, these two examples of adultery and here in live-in relationship, this relationship which I'm emphasizing is legal, particularly live-in relationship, is illegal. Sorry, it is not valid, though it may be legal, that it is not a criminal, but it is not valid from the point of view what we are saying, civil law or criminal law. Let me give you one more example, and that of homosexual relations. Again, the judgment of the Supreme Court of 2018 at itself, Navtej Singh versus Union of India, comes in our mind, which has decriminalized consensual homosexual sex. And before that, in 2014, we had a judgment again from the Supreme Court, Nalsa judgment, wherein breaking the binary of male and female, the Supreme Court has recognized the third gender and also recognized the fundamental rights of the third gender, civil rights of the third gender, right? Again, the same question. If two persons of the same sex or homosexuals or third gender, adult, with consensus, are living together, cohabiting together, by virtue of Navtej Singh, their relationship is legal. It's not offensive, no punishment, no prosecution by the police. But the same question, if we ask herein also, whether their relationship is also valid, the answer is not clear. Again, the law is evolving in this area. It is evolving, right? And so far, I have given you the examples of decriminalization and then have tried to explain how the valid relationship and legal relationship are really different on the same set of facts. Now, let me take a reverse of it. Now, let me talk about criminalization of certain relationship. Yeah. We have been talking about so much these days about the marital rape should be made a crime. As a matter of fact, certain petitions are also pending in the court. Okay. Let's presume for a while that tomorrow marital rape is recognized as an offense. So that act between the husband and wife will be illegal. Yeah. The husband can be prosecuted, sent behind the bars. But whether that act will also become invalid, the answer is no. The act will remain valid, though it will become illegal, with the consequences that if any child is born out of that act, no question of illegitimacy about that child can be raised. Now, in my presentation, nowhere I have gone to that kind of the aspect, whether marital rape should be recognized or not, whether homosexual relationship should be made valid or not, so on and so forth. That's not my emphasis as far as this address, which I'm making very focused, is concerned. What my endeavor is that how do we understand the law? Our opinions all right, our views all right. We can very eloquently place our views and opinions. But as a law teacher, as a law student, as a law researcher, first of all, we have to understand the law as it is so that we can really criticize it in a better and a stronger way. So in order to have your views, your opinions on all these things, particularly the changes perspective, which I have taken, be it marital rape, homosexuality, adultery, or live-in relationship, first of all, we should understand the nuances of all these kind of the terms or the consequences of this, which I have tried to explain with the help of just two, which otherwise seem to be very simple expressions: validity and legality, which may be similar in certain situations, but need not necessarily be applicable to the same set of circumstances. So, I believe that when the students graduate in law, they should be, I've been very clear about these, what I believe are the basic understanding of law or the basic terms, particularly with reference to the family law. If there are any questions, I will be most happy to entertain them. And thank you very much for your patient hearing. Thank you.
Thank you so much, ma'am, for your valuable words of wisdom. Now, we have Dr. Sindhu Tulsidharan, ma'am, Head and Associate Professor, Department of Law, University of Kerala. Ma'am has over 10-year teaching experience at postgraduate level. She is also a graduate in chemistry. I'm privileged to invite Dr. Sindhu Tulsidharan, ma'am, for the special address. Ma'am, please.
Thank you. Respected dignitaries of the panel, respected teachers, dear students, I first of all congratulate Kerala Law Academy Law College for selecting such a topic for your 11th International Conference, which, as of the preceding speakers has said, attracts much relevance in the day-to-day world. And I'm also so happy to be with very eminent scholars like Professor Anil Varid, Professor V.S. Elizabeth, Professor Usha Tandon. And as our preceding speakers have said, we should address what family law has been facing in the contemporary world. And we know that I should concentrate my views on the Constitution of India. So I'll start from Article 44 of the Constitution, where the Constitution is giving a mandate to the state to endeavor to secure for its citizens a uniform civil code throughout the territory of India. So what does that mandate mean? Originally, when the constitution makers were drafting the Constitution, they meant that everything that is a part of the secular portion of personal law shall be brought within the purview of uniform civil code. So why I said is that when I say that state shall endeavor to secure for its citizens uniform civil code throughout the territory of India, it is a directive principle, isn't it? It's only a directive given to the state. It can't be done at a single stroke of the pen, isn't it? In one stroke of pen. It can't be done in haste. It can only be done very gently, that is very cautiously, then with statesmanship, then with calmness and with sympathy, isn't it? Because we know that all changes have to be brought in without inviting discontent among the people or without breaking the harmony of the society, isn't it? So if you're going to discourage people from following the personal law, that will bring in hatred into their minds against the ruling party, isn't it, or the ruling government. So we can do it only step by step. So that is what is seen now. And we know that what we shall have to assure is that, as our constitution makers have intended, we'll have to assure that when we implement a uniform civil code, it shall not violate the fundamental rights. It shall not be tyrannous for the minority. So is it violating the fundamental rights? So when I mean fundamental rights, I mean right to equality. Then I mean freedom of conscience and the right to freely profess, practice and propagate religion under Article 25 of the Constitution, whether that is preventing people from practicing, from propagating or from professing their religion. If so, that will be infringing the fundamental rights. So how far state can exercise its control upon this? The state can exercise its control as the fundamental right in Article 25 itself says in subclause 2. It says that the state can bring in restrictions on secular activities, economic, financial, political, and secular activities associated with personal law. So what does it mean when we say secular? We know that secular in India doesn't mean anti-religious, isn't it? It is not irreligious, but it is non-religious. So whatever is there in a personal law, which is not religious, can be regulated by the state. So why can't we take all this as irreligious? Say, for example, we have to take a contract, as we have taken Contract Evidence Negotiable Instruments Act. We can also take marriage, we can also take divorce, succession, inheritance, isn't it? So what we have to set apart, or we have to partition it into two, that is the essential religious rights can be parted from the non-essential portion, religious portion, isn't it? When I say essential religious right, you can't take away the practice of tying bride knot, isn't it? You can't take away the practice of proposing, taking oath or affirmation that we shall always stay blessed as husband and wife. We can't take the part of contract that is existing in Muslim personal law. So all these are religious. Muslim, that is marriage as a contract, then marriage as a sacrament in Hindu law, as a part of status in Christian law. So all these are part of the religious rights that is performed as part of personal law. So except those religious part, all others can be regulated. All others can be regulated by the state. Why is it said so is that we know that almost every aspect of marriage has been regulated, isn't it? We have recently, we said that we were of an opinion that marriage law, that is Muslim law, is immutable. It can't be changed. It is immutable for the sake of enforcing uniformity among the Muslim community, for enforcing the same law throughout the members of Muslim community in India. But I don't think that is right, because we know that to start with, we had Muslims who followed even Marmakataim law in Kerala, isn't it? Dayapaga law in same law, like matriarchal law in Bengal. In northwestern provinces, they followed Hindu law. Central provinces, they followed Hindu law. Then in also in United Provinces, in Bombay, in all these portions, they were following Hindu law in the pre-independent time. And we gradually changed it step by step. It was not in haste. So all these aspects, all this related with personal law were changed. Part B State Laws Act came, State Reorganization Act came, Hindu Succession Act was implemented, Marriage Act was implemented as throughout the continent. So what we can say is that as our perception has changed, that is Muslim personal law is immutable and can't be changed, other perceptions are also seen changing, isn't it? So when the court says that, we know that in northwestern frontier provinces, the Shariat law came into being through a statute. That is the Shariat Application Act 1937, Dissolution of Marriage Act. Then came the Muslim Women Protection of Rights on Divorce Act 1986. Then came the Protection of Muslim Women on Marriage Act, protection of Muslim, that is protection of rights of Muslim women on Marriage Act 2019, after the Shaira Banu case, where triple talaq was held to be unconstitutional and void. And that was made a law, that is Muslim Women Protection of Rights on Marriage Act 2019. So everything has been changed except interstate succession and inheritance. So what is, and succession, inheritance and succession. All aspects other than inheritance and succession has been changed. We see that only the two aspects remaining is interstate succession and succession, the testamentary succession. So to a certain extent, there is testamentary succession in the case of Hindus and Christians, but and all other communities except Muslims. But you know that we can take, when two or more civilizations merge, when two or more cultures merge, you know that personal law is a part of religion. It is as well a part of culture, isn't it? So when Hindu and Muslim culture merge, we can take the best in the other culture, isn't it? So we must influence the other culture as well as we must be influenced by the other culture. So you can take what is good in that. Because in Muslim law, they can't make testamentary disposition above 1/3 of the property. So that can be taken into consideration by the other communities, isn't it? So what we require is a unity. We can't simply say that ours is a as a unified nation. If simply we say that ours is a unified nation, that won't be that won't be a correct perception, isn't it? We can say it if it is in effect a consolidated unified nation, and that we can prove by following personal law with our ways of life, by building a consolidated, by proving that we are living in a consolidated and a nation of integrity. So there we can prove only if we can in effect add to what is unity and integrity of a nation. So what we need is a uniformity in the personal law that we have attained to almost, I said, all levels in marriage, divorce. So we are advancing step by step. Why should we say that the state should not implement a UCC? There is nothing to reject or nothing to reject such a notion, isn't it? The state should try to implement. It is only a directive. The state can't do it at a haste. It can only do it step by step. So that is being done. We are seeing that it is being done. And the second one is we can't say that any community is self-contained, isn't it? There are a lot we need to fill in. And therefore, we will have to realize that we'll have to accept what is good in other communities and march forward. So if we want to have a new society, a democratic society, a well-built democratic, consolidated nation, then we'll have to prove that we live in with our personal law. We have to live in with our personal law through unifying the entire aspects, which we can consider as secular. So you can consider marriage, we can consider divorce, we can consider interstate and other modes of succession as part of secular activity, isn't it? We can get rid of the essential religious rights, say, as we said, the marital rights which we follow. We can get rid of that. So except essential religious rights, the rest has to come under UCC. And it is coming, it is being brought under a uniform perspective, being brought under in their own law in a uniform perspective, which we are witnessing nowadays. So I say that interstate succession and testamentary succession to be brought within a uniform a civil code, because if you are going to make it a part of personal law, you know that states won't be, if it is going to be considered as a part of religion, then state will be prevented from interfering with it, isn't it? Then is that violating fundamental right of women's right to equality? It is violating Article 14, and it is also violating discrimination on the basis of sex under Article 15, isn't it? We have non-discrimination on the basis of sex, which is in our Article 15 of the Constitution. So interstate succession and inheritance is in violating that also, isn't it? And also it is preventing our reformers from making provisions for elevating women to the status of man, isn't it? So no woman is seen elevated to the status of man in the matter of inheritance and succession, particularly Muslim law. So Muslim law is following their own law, but that is Shariat, their personal law. So we can say that to a certain extent, women are being considered unequal. So if you want women to be elevated to the same level as that of men, then we'll have to consider interstate succession, all modes of interstate and other modes of succession as well under secular activity that is contained in Article 27(2) of our Constitution. Whereby state can regulate all this. So that is what is needed, a perception of a uniform civil code that has to be brought in for bringing in gender equality in all sorts of personal law among all communities. So with these few words, I conclude my speech. I thank the authorities for inviting me to be a member of the panel. Thank you.
Thank you so much, ma'am, for your words of wisdom. Gratitude is the fairest blossom which springs from the soul. Every celebration is an experience as the external fades away and the internal lingers and echoes in the most depths of our heart. We are reminded that events like this one are milestones on the journey of life and reminders of God's fidelity all through. Now, it is my pleasure to invite Vidya Vivi Ma'am, Assistant Professor, Kerala Law Academy, Law College, to propose the vote of thanks. Ma'am, please.
Thank you, Manipriya. Good morning to one and all. Most respected Professor Dr. Anil G. Warriat sir, Professor Dr. V.S. Elizabeth ma'am, Professor Usha Tandon ma'am, Dr. Sindhu Tulasidaran ma'am, Advocate Dr.N.Narayanan sir, Professor K. Anil Kumar sir, Professor Harindran K. sir, other eminent personalities present in this virtual platform, parents, teachers, dear students, and participants. I consider it as a privilege and pleasure to propose the vote of thanks to the dignitaries of today's inaugural address of 11th International Seminar on Family Law, Changing Perspectives, Contemporary Challenges and Solutions, organized by Kerala Law Academy Law College in association with Center for Advanced Legal Studies and Research, KELSA, Thiruvananthapuram. I extend my heartfelt gratitude to the late Dr. N.Narayanan sir, founder, Kerala Law Academy, who always remains as an inspiration for us in conducting these events. It is our pleasure to have the esteemed presence of Professor Dr. V.S. Elizabeth ma'am. We have been listening to the most thought-provoking and informative inaugural speech delivered by ma'am, and we sincerely appreciate the generosity and readiness to accept our invitation. We are highly indebted to you, ma'am, for sparing your valuable time. On behalf of Kerala Law Academy, teachers, students, non-teaching staff, and on my own behalf, I propose a heartfelt vote of thanks to you, ma'am. I express my sincere gratitude towards Professor Dr. Anil G. Warriat, Registrar, MNLU Mumbai, for the presidential address. Thank you so much, sir, for enlightening us with your words of wisdom. I express my sincere thanks to Dr. Sindhu Tulasidaran ma'am, Head and Associate Professor, Department of Law, University of Kerala, from the bottom of my heart. Thank you so much, ma'am, for delivering the special address. I would also like to take this opportunity to place on record our hearty thanks to Professor Usha Tandon, Dean and Head of the Faculty of Law, Delhi University, for her thought-provoking keynote address. We are truly thankful, ma'am, for enlightening us. With immense respect, I would like to extend my vote of thanks to Advocate Dr.N.Narayanan sir, Director of Kerala Law Academy, Advocate, High Court of Kerala, Special Government Pleader, Forest, High Court of Kerala, Chairman of Kerala Law Academy Moot Court Society, Member, Bar Council of Kerala, who is my teacher and mentor and always a fountain of constant support to all the activities in this college. I am indebted to him for being the catalyst that stimulated us to do our best and for standing as a pillar of strength. With a deep sense of respect, I thank Nagaraj sir for his untiring efforts. On behalf of Kerala Law Academy, teachers, students, non-teaching members, and on my own behalf, I propose a sincere thanks to you, sir. I take this opportunity to thank Sri Anil Kumar K. sir, Director, Faculty and Student Affairs, and Professor, Kerala Law Academy Law College, for providing constant guidance throughout the event. I thank you, sir, for always helping us to manifest our abilities in ways that we could have never imagined. Sri Harindran K., our principal, is always a source of inspiration to all the academic activities in this college. He always extends his support and guidance to all the competitions, conferences, international seminars, and workshops organized by this college. On behalf of Kerala Law Academy, teachers, students, and non-teaching members, and on my own behalf, I propose a sincere thanks to Sri Harindran Sir from the bottom of my heart for extending a warm welcome to the guest on this auspicious occasion. I extend my heartfelt thanks to the faculty conveners, Professor Anil Kumar G. Sir, Professor Ajita Nair L. Ma'am, Dr. Dakshina Saraswati Ma'am, Srimati Arya Sunil Paul Ma'am, Sri Varun Dev S. Sir, and student conveners Gaudam Vishwam, G.S. Gokul, Lakshmi V.S., Anjita Unitan, Deviga S., Ashwin Rajiv, Anaga S., Gauri A.H., Nandakishore S., Namita Babu Benedict for their tireless efforts in making this event reach its epitome. I express my special thanks to our IT team who have provided us with the technical support which is significant due to the virtual nature of this event. Now I conclude by extending my sincere thanks to all the parents, students, teachers, non-teaching staff, and all those who are present here to make this function a grand success. Thank you all and have a nice day.
Thank you so much, ma'am, for expressing your heartfelt gratitude for this inaugural session. With that, we have come to an end of our inaugural session. On behalf of our institution, I would like to thank all the dignitaries for joining us and enlightening us with their valuable words.
I extend my heartfelt thanks to all of you for your kind cooperation and patience. Thank you, everyone. Have a great day ahead. This is Manupriya Chellan, along with my co-anchor, Akshara Dian, signing out. Thank you.
Thank you. Thank you.
Thank you.
सर आपसे डिस्कशन करेंगे किसी दिन अच्छा लगा
Thank you.
बस nice to hear
I have your
so
number.
many aspects.
Yeah.
So we'll
Yes, madam.
आप आइए कभी